Medellin versus Texas is, which the court's going to hear soon, is I think the most procedurally complicated case I've ever seen. It took me the whole weekend to figure out what was going on in this case. Okay, so bear with me for a moment. The United States and Mexico are both parties to the Vienna Convention on Consular Relations. Article 36 of that convention says that the signatory states are to notify when they detain a foreign national, they are to notify the other country's consulate about the detention and the potential criminal trial, and give them the right to request assistance and give that legal assistance to the individual. Now, the optional protocol to that convention, as to which both the United States and Mexico were signatories at the time, said that the International Court of Criminal Justice shall have compulsory jurisdiction to decide disputes, Article 36 disputes. The United States has subsequently withdrawn from that optional protocol. So what happens in this case is that in 1993, Medellin is arrested for 2 rape murders. He's a man who had lived all of his life in the United States, though he is a Mexican national. He told the arresting officers that he was a Mexican national. They did not give him access. They didn't notify the Mexican authorities about this. And while he was in police custody, he confessed to the murders. The case goes to trial in 1994. He is convicted and sentenced to the death penalty. And in 1997, the Texas Court of Criminal Appeals affirms. And at no time during his trial or appeal did he raise this Article 36 issue. In 1998, he files a state habeas corpus petition raising this Article 36 issue. And the trial court denies relief on the ground that it is procedurally barred because he didn't raise it before, and because they say it wouldn't have made a difference in his case even if he had raised it because he had some other counsel at his trial. And that decision was affirmed by the Texas Court of Criminal Appeals in 2001. In 2003, the Mexican government initiated proceedings against the United States in the International Court of Justice, saying that Medellin and 50 other individuals were deprived of their consular access rights. And the ICJ agreed with Mexico and said that there was a violation, and that the court and ordered the United States courts to reconsider the convictions and sentences, notwithstanding the fact that they might have been procedurally barred under state law. In 2003, Medellin filed a federal court habeas petition, and that was denied by the district court, which said, well, it wouldn't have made any difference even if you had consular access because you had other counsel at trial. In 2004, the Fifth Circuit affirmed this decision and said basically that the Vienna Convention didn't confer any private rights on the individual, that the Vienna Convention was really about the rights of the Mexican government, but didn't give Mr. Medellin an ability to walk into court and try and enforce those rights as part of his defense. Medellin then asked the Supreme Court to hear his case, and the Supreme Court back then in 2004 agreed to hear his case. In 2005, the President issued a declaration saying that state courts, including Texas, were to provide the required review under the ICJ's Vienna decision and had to consider this Vienna Convention argument. The Supreme Court then withdrew its grant of certiorari, dismissed it as improvidently granted, figuring that the state courts will sort out the meaning and effect of President Bush's determination. In 2006, the Supreme Court heard a different case called Sanchez-Lama versus Oregon, which agreed with that Fifth Circuit determination that I told you about a moment ago, in a separate case, obviously, that the Vienna Conventions create no privately conferable right on an individual. The issue that the Medellin case raises is, does this presidential decree ordering enforcement of the Vienna decision require the state courts in Texas to comply and listen to the President's determination that they must consider these Vienna Convention claims, notwithstanding the procedural bar under the applicable law of Texas? The petitioners obviously they have a hard time in this case. Mr. Medellin has a hard time in this case insofar as Sanchez-Lama already said, and there were 5 votes for the proposition, that there was no privately enforceable right under the Vienna Conventions. And so what they are saying is, our case is different, because that was the kind of general freestanding claim about enforcement. Here you have the President saying that that the state courts have to comply with a specific order with Mr. Medellin's name attached to it. That is, that he was part of the Avena decision. And so on grounds of presidential power and on all of the doctrines that say that the nation speaks with one voice in foreign affairs and the like, here when the President is telling and ordering the state courts to enforce a decision, they must be bound by it. The state of Texas obviously disagrees and finds this the most egregious abuse of executive power since you name it. And it's a really enormously interesting case because you have the executive on the side, in one sense, of this person who is facing the death penalty.